Welcome, Mr. Lynch. Thank you for coming. And we also have your written testimony submitted, so thank you very much for that.
Good morning and Happy New Year. I guess the beauty of public hearings is you get to hear both sides of every issue, sometimes back to back. My name is Dan Lynch. I was born and raised in Waterbury, and I've lived in Trumbull for the last 20 years. I'm here to testify in support of what I believe is a need for urgent change to general statutes and court rules, which I believe are currently causing life-altering harm to children and families of divorce in Connecticut. 3 specific points. I believe that we need to adopt a presumption of shared equal parenting, an equal sharing of both physical and legal custody. I believe that we need to address party non-compliance with and the court's failure to enforce current General Statute 46B56. And I also think that we need to abolish the role of guardian ad litems and attorneys for the minor child and replace them with effective, transparent, qualified, and accountable professionals working within a system that serves the children and not uses the children. I don't have the words or the personal experience to convey in 3 minutes the importance of the matters that this task force was charged with. I wish I did. I've watched several of the hearings on CTN. It appears to me as if there's not even consensus amongst the task force members of the true depths of the charge that you have before you, a very important charge. More troubling, it appears to me that there's an obvious and deleterious conflict of interest that exists in the very appointment of 2 co-chairs who are deeply entrenched and beholden to the very system that's in sore need of a transplant. There's no system or group anywhere in the world that's perfect or without flaw. I think everybody would probably agree there. But sadly, there's a range of issues harming children and families in this state which seem to be routinely ignored. Children are being used as pawns in the state of Connecticut. As you hear testimony today, I'd say, think of your children, if you have children. Think of your grandchildren. Think of your nieces and nephews. Think of your neighbors' children, your friends' children, okay? Their innocence and unlimited potential is being maliciously destroyed by those who view them as a meal ticket, who can be leveraged for legal strategy or financial gain. Our current statutes provide fertile soil for far too many less than ethical attorneys who are more interested in the numbers on a financial affidavit than they are in the ages of the children of the clients that they're serving.
Let me just repeat my comment, please, about restraining yourselves so that we can keep things moving along.
By adopting a presumption of equally shared parenting post-divorce, certainly subject for review for legitimate and well-documented exceptions. I think there's no question on things like that. It's my firm belief that a substantial number of cases would never be labeled as contested or limited contested. 6 years ago, my daughters were 14 and 11. Our family had no debt. We had substantial savings, substantial equity in a home that we had purchased 4 years earlier. Little did I realize that a failed marriage meant that families like us were prime targets for the bottom feeders carefully stalking their next prey. Please, eliminate the opportunity for children to be used as financial pawns in a perverse game of legal chess, and you will likely preserve the assets that should rightfully be used to fund their educations rather than the vacation homes for their attorneys. And in closing, I say, I must take exception to those task force members who have, in earlier hearings, as I've watched them on CTN, who've suggested that the oversight provided by statewide grievance or the judicial review councils are legitimate alternatives for peer review. This is simply not true. I have worked in both of those systems. And sadly, the fact that there are flaws in those two have contributed to the breadth and depth of issues that continue to harm the families and the children in our state. And I will close with a quote that I've used before in public testimony, which is what motivated me. Dr. Martin Luther King, Jr. He says, our lives begin to end the day we become silent about things that matter. And so my final words are, my children matter to me. All children matter to me. And the time for talk is past. The time for action is now. Don't kick the can down the road any longer. recommend that we take actions that will immediately benefit the children throughout the entire state of Connecticut.
Thank you very much. And are there any questions from task force members for Mr. Lynch? Representative Gonzalez and then Mr. Weissmuller.
Thank you, Madam Chair. And thank you for coming. I do remember you the last time that you came here to testify. And I see that you're still in pain, but I think that you're getting better because the last time it was kind of impossible for you. And I will tell you that you're not alone, and I know that you've been spending a lot of money, but I would like to know how long during your process, how long it took your process, your divorce, and or you're still in court?
I was in court Monday, and I'll be in court next Monday.
So for how many now? What is it?
It's 6 years ongoing, in excess of $250,000 of litigation on both sides, and it could be well more than that, but that's certainly a number easily off the top of my head.
Okay, when you said 250,000, it's only what there's a part of that money goes to lawyers or guardians ad litems.
No, in my case, very different from others. No guardian ad litem involvement whatsoever. We actually do have 50-50 shared physical and legal custody. It certainly would have been nice if both parties cooperated in the orders of the court, or maybe if the court enforced the orders that were in place.
So yeah, that was my next question. If you think that the court are imposing, the court order, because there's a lot of parents there saying that it's like a joke. The court are not imposing the court order, and you agree with that?
I could only look to not only my case, but as I sit and wait for my case to be heard, often, sadly, in the Bridgeport courts and also in Middletown, I get to sit around and listen to other people's cases, which is equally sad. But no, I think consistently, every time I'm there, I'm hearing situations, but you only know what you hear. I can look at my situation, and I know clearly the facts, objectively on both sides of it. And with the frustrating thing is when you're both two very involved parents since day one. No issues ever, no police involvement, no nothing, no anything until attorneys are involved and there's substantial assets on an affidavit. Suddenly, maybe one person gets planted the idea that there's, custody can be used to sway financial award, and then suddenly there's requests for sole custody or significant custody, and maybe there'll be visitation for the debt. Let me not go down that road. But in the end of the day, by the court looking the other way for as long as they have, certainly in my case, it's enabled alienation to exist, and it's certainly it's painful.
I know. And well, thank you very much for coming. I really appreciate it because, like I said, I do remember you for the last time, and hopefully, I know you've been there for 6 years. Hopefully, I think we're trying to look for solutions here, and I think that you're not by yourself. We have a lot of parents, complaining about the same thing. Hopefully, we'll see if we can find some solution to this.
Yeah, and I may not agree with everything I've heard in every task force and every individual. I appreciate the effort and the time that everybody here is putting in. Whether I agree with your position or not, I recognize this is time away from, other things you could be doing. And so I appreciate that as well.
Thank you.
Mr. Weissmuller, you were next.
Thank you. Part of my question was asked, but I'll skip to the mechanism for enforcement. Some states have mechanisms for enforcement that allow basically for someone to demonstrate that there is noncompliance and then have the other individual appear and show cause in an abbreviated hearing that they are either in compliance or that there's a reason why they cannot comply with an order. And that process is revisited until there is either full compliance or an amendment that can allow people to comply. For instance, child support. Someone doesn't pay it, it's very clearly established. One person comes in and says, I haven't seen anything, no money. The other person comes in and says, well, I can't pay. I've been unemployed, and they build an arrearage, but they're not voluntarily non-compliant, right? Did you transfer custody on, or access, whatever term of art is used, on the date in the order? Answer simple, yes or no. Why? Next question. If they can't demonstrate that they are trying to comply but cannot comply, there's a violation. And in the system that I'm familiar with, a sanction is immediately ordered, basically saying that if this doesn't happen immediately with a reparation of days, next week you're going to be asked to come back and you'll be fined for every day it doesn't happen. Did you find that type of a mechanism when you entered the Superior Court and tried to enforce your order?
You know, it was everything I could do as you were asking the questions, not, you know, I mean, if you saw me smiling, it certainly wasn't because I enjoy this. It's because it's almost become comical to me in some respects. What you've just described, if all of those things were taking place, you know, I probably wouldn't be sitting here. My guess is that, you know, other people wouldn't be as upset and frustrated with the system and so forth. You know, the one thing that I found in answer to this question is when you, first of all, as a self-represented party, not by choice but by circumstance, you know, it's been since October of 2010 that my counsel, you know, filed a request to withdraw, and it was immediately granted, not because of any request, because I couldn't afford to pay the bill anymore. And when I wouldn't succumb to the demands of, you know, keep writing a check, which I had no money, he knew I had no money. The reason the orders were on appeal was because there was no money. You know, I don't know the percentage. I think it's fewer than 1 or 2% of divorce, you know, judgments that are overturned on appeal. Mine was one of them in 2012. But the issue is you walk into the court as a self-represented party, somebody who's appealed a case, somebody who's filed a judicial grievance, somebody who's aggrieved an attorney. You're a target. You're a target for retaliation. There is no accountability. You're lucky if you get the basic constitutional rights to have a meaningful hearing. Repeat way too many examples, and I don't know, I'm sure more than 50 different transcripts at home that I've had to use for the various appeals. Routinely denied access to called witnesses, routinely denied the opportunity to present evidence and have meaningful hearings, motions that are delayed for months at a time. This past Monday I had a simple motion for modification that was heard Monday. It was filed on May 17th, 2012. Delayed, transferred to this court, transferred, and then the other court said, I think it's supposed to be up there, and let's go. I mean, and this is not just one motion, over and over and over and over. But once again, if your case has a certain name on it and you're a pro se party and you walk in and, oh, you know, you're lucky the other attorneys, sometimes they don't show up, and then it's, well, somehow it gets rescheduled. If a pro se party pulled that, you know, I mean, I've been incarcerated because of orders. I was found in willful contempt of orders which were on appeal. And of course, what do they say? Well, after 31 months, 911 days, the appellate court, you know, largely ruled and said, okay, you know, they threw out all the financial orders and they sent it back to a new trial. Well, that's great. You can't undo a strip search. You can't undo missing your daughter's prom. I mean, I've said these things before. There's, you know, far too many examples of things that can't get fixed by an appeal. And anybody here with a law background of any, you know, any substance whatsoever, you know, lawyer or not, there's people who work close to the system who understand the law. Trying to be successful on things like an appeal, it's nearly impossible. I mean, everything is controlled by the judge. And so the judge issues the orders. The very orders that he issues that you can't live up to, you then appeal because he denies re-argument and he denies, you know, clarification or articulation on them. So then you request a fee waiver so that you can maybe get a fee waiver and appointment of counsel under 63-6. They say no. So then you take an appeal. The other side files a motion for contempt. Okay? Now you're facing a contempt charge. You could be incarcerated, and I have been. They could dismiss your appeal if you're found in contempt of an order while there's an appeal pending. I mean, there's a whole range of wonderful things. But if you're somehow, you know, successful in being able to survive the death march all the way to the very end, you know, I don't know yet. My appeal's still pending. Oral argument hasn't been scheduled for the second appeal yet. And so I imagine their goal was, you know, let's just see how long we can get before maybe we can get this guy to bleed out. Well, it hasn't happened yet. It might. I don't know. But if, you know, I wish I had the exact script of your questions. Everything that you just asked in that question, that, you know, if all those things were taking place, I think that things would work much more smoothly. Those things are not taking place. I took exception to the gentleman, although I respect his testimony, and I forget his name, but I believe it was the second gentleman who testified today, saying, there's no change that's needed. I disagree. I'd love to go to court with him one day and just the two of us, just as two guys, just sit together and listen to somebody else's case in some other courtroom.
Attorney Allard was next.
So one of the first statements you made was that guardian ad litem should be abolished, but you haven't had a guardian ad litem, so why do you make that statement?
I wish I could tell you the number of hearings that I've had where I've sat and listened. And incidentally, there was an attorney for the minor child appointed in my case, not a GAL. I met with the AMC. What you need to understand with my comment is that comment is actually subordinate to my first strong recommendation for the equal parenting. Now, I do recognize, and I want to reinforce this out of respect to the woman who testified just before me. My recommendation for the equal parenting is to eliminate what I feel is the financial motivation for somebody to pursue custody. I do indeed recognize that there are legitimate concerns, certainly for issues of mental health or violence or addictions or whatever, but even some other very real issues of parents, for whatever reason, who choose to live a distance from one another. We live 2.2 miles away from one another. We've made it work. Our daughters have thrived. I've watched their grades go up over time. But the guardian ad litem fees in the state of Connecticut, and I can't speak to the AMC issue as closely, but the guardian ad litem fees it's essentially an unchecked, unbalanced, runaway meter that parents have it's not transparent. They have really, there's no accountability, there's no transparency into something that's bankrupting families. And when I say bankrupting families, it sounds bad enough to say the families and you think about the parents. These children need to go to school at some point to go on and have productive careers. And so
Okay, thank you.
that's the basis for the...
Attorney Dornfeld.
Morning, Mr. Lynch. I'm Sharon Dornfeld. You said that you've been at this for, I think you said 6 years. You're not still, you're already divorced, is that correct?
The divorce was one of the few items in the original appeal that was affirmed. Yes.
Okay. So you did not,
The appellate court wisely figured that we probably weren't going to reconcile, and so yes.
sometimes the courts get it right.
The dissolution date was maintained as September 15th of '09.
so for the 4 years plus since, even though you have shared custody, that has not been the remedy for the conflict between the two of you, is that correct?
I'm not sure I understand the question. I'm sorry.
Well, so you are actually divorced, and you have shared custody orders as a result of that divorce, as I understand it. Is that correct?
Yes, correct.
Okay.
Well, there were two sets of orders. I mean, there was an original judgment, then there was a 31-month appeal, and so you have all that wonderful post-judgment stuff going on while the appeal's pending.
All right.
Most of which has stayed, some of which isn't. Custody's not, of course. You know that.
Well, that's my question. Has custody been what has been in dispute for all of this time?
No, not at all. Custody was never. Well, the first when we had our very first intake meeting with Family Relations, and they ask you your name and all the basic stuff. There was no problem.
Okay. So shared custody, if I understand it, has not really been a panacea for the problems you and your ex-wife have experienced for the last 4+ years.
Well, no. I want to be careful. I want to make sure I'm answering your question, so that's why I hesitate. The initial thought with working with Family Relations on day one, literally, I think the very first time the paperwork was filed, or the very first meeting we ever had, was it was going to be, equal. At some point in the process, very early on, I don't know, I think it was probably, within a week or two of the financial affidavits being submitted, suddenly there's a change of heart. And now it's, wait a minute, this is going to never work for the kids. And so then had all sorts of, it ended up being a year before we even had an agreement on, I simply all along was this 50-50 shared vehicle. That's what we've always done. Who's driving to dance today, who's coaching this,
Right.
who's volunteering at the school. And then what? Now we have to have two separate evaluations by Family Relations to come back and say, yeah, this is tailor-made for 50-50.
So is your situation do you believe it's driven by the financial considerations, some of which may follow from the deviation criteria, which includes shared custody?
I think that one of the significant contributors, I have to say this carefully, one of the significant contributors, in my case, from day one, was tied to the unethical conduct of an attorney who I pursued a grievance against, where probable cause was found, where a public hearing where Attorney Cousineau was among the members on a panel to prosecute, and just days before the final decision was going to be released, he was allowed to resign with a waiver.
But I'm still trying to get an answer to my question here, which is, was it financially, the concern is that the problems have been financially driven, and that is partly a function of the deviation from presumptive child support amounts for shared custody? Is that
Well, it's been a whole collection of financial things, so yes, I guess the answer is it's all financial.
All right, it is all financial, okay.
Yeah, it's not fighting over, the kids really should have been with me. That was never part of the,
Good,
that was never
good.
part of the file, that was never part of the appeal.
Things worked out as they should. You and your wife were able to agree on what was best for your kids, and I'm glad that that has worked.
Yeah, well, the tough thing about it, I will say, is it's one thing to have something on paper. It's another thing where, what am I going to do? I'm not going to call the police and say, get her over to my house, because I have too much respect for my daughters, and as a result, by me putting her needs above my own desires, sadly, the alienation has taken place, and after 3 years, it's been about, my daughter speaks to me occasionally after 3 years because of the alienation. Prior to that, wonderful, totally involved, perfect, great relationship.
All right.
So.
All right, thank you.
Sir, I just have a question. When you talked about delay, so the flavor I'm getting is that you and your wife have a shared parenting, a pretty equal shared parenting, but, and correct me if I'm wrong, she's not following it. She's not facilitating that schedule, is that correct?
That was correct with respect to one of my daughters.
Okay.
Not the other.
And then you talked about all the delays in court. Can you, and if you can, tell us why those delays happen? Do those delays happen because the court just doesn't ever schedule your hearings, or they just keep continuing them, or an attorney keeps interfering and putting it out? Is it all of the above? I think we're trying to figure out how to get these things heard more quickly, and so if you could help us to know what prevented yours from being heard more quickly, it would be helpful.
I'll give a quick answer, and I'm only going to make it quick because out of respect to everybody else's time, and I'm happy to chat, like, maybe at the lunch break with you or something about it.
I think we've decided that we're not going to actually take a break. People can leave and come back because we have so many people. If we took a break, it really wouldn't be fair.
I just want to do that in respect to the folks behind me. But in answer to your question, there are a lot of tactics, as I've learned, because I've been to court so many darn times now. There are a lot of wonderful tactics that are being used to delay things. Even shuffling from one judge to another, where suddenly it's, okay, now this judge who really has kind of no idea. But first of all, even to get the hearing scheduled.
Right.
And so when you're, especially when you're a self-represented party, and you have the other attorney who will simply just say, not available that day. I just got appointed by a judge to go here. I got appointed month after month after month. I had a situation with the same attorney who I had aggrieved, who back in 2011, early September 2011, 2 days before a hearing that had already been delayed for months, requested a continuance. He requested a continuance to like September 25th. There's some very specific date on the okay, I mean, I sent in an objection saying this is going on long enough, but the court granted it. Okay, now the calendar's marching forward. Now we're 2 days before that Thursday hearing. He files another continuance. He says, oops, I had forgotten when I requested it that it's the Jewish holiday, and now I need to request, another request for a continuance one day saying he's in court, and I saw him at a golf tournament.
So you think it's the court approving continuances and facilitating things not happening? Is that I just want to...
I think in many cases it's preferential treatment with local counsel who's in there every week. And you know what? Folks get very friendly. It's their coworkers, and it's a, hey, by the way, you know what? I need a quick favor. I really need to move this thing. I can't be there. My client's out of town. Whatever it is. And pro se party is really... It took me the first 2 or 3 years to figure out how to even deal with some of these things.
All right. Thank you very much. Representative Gonzalez, I apologize, I didn't see your hand.
No, and thank you for the second time, and I know that we had got people waiting, but question. Knowing that you had to go back to court, that your case still pending, because we heard about gag orders and all of that, but knowing that you had to go back, are you not afraid to go back in court now after you came here to the public hearing? Do you think that this is going to hurt you?
You know, I've been sent to jail. You can't hurt, you know, I mean, the things that I've already been through, there's other folks who've been through far worse.
I know.
Am I afraid? You know, I'm confident, sadly, that there will be some, you know,
Consequence.
retaliation, but you know what? It's very careful how it happens, and it's judicial discretion. It's, you know, it's not an abuse, whatever. I'm going to continue to speak forward on behalf of an issue, because there are dozens of people and families and stuff who, years from now, who will benefit from folks like myself and many others here who are going to have the courage to speak out about things. Change is going to happen slowly. It's not going to be some huge, it's all done and it's all fixed. And even when change is made, there'll still be problems. But the fact that the problems are so pervasive, so well-known, I've had attorneys who have pulled me aside after hearings, and attorneys I didn't even know, who've pulled me aside, complimented me on, you know, hey, as a pro se, you did a great job, and I got to tell you something, you know, and then they share kind of their view of, I wish some of these problems get fixed. Because they're, you know, and I'm, you know, give you the impression, there's some wonderful attorneys out there as well. So.
Thank you very much.